If you're separated with children, you may be wondering, can I move with the children? Or can my ex move with the children? Hi, I'm Jennifer Sorensen. I'm a family lawyer here at Turnbull Hill Lawyers. Today I'll be speaking to you about when you can and can't move away with your children and what you can do if your children move away without your consent. As a parent of a child, you hold parental responsibility. This means you should attempt to consult with the other parent and make a genuine decision about major long-term issues in your child's life. A major long-term issue includes any change to the child's living arrangements that makes it significantly more difficult for a child to spend time with the parent. In circumstances where you want to move with your children, this may make it significantly more difficult for the other parent to spend time with the children. As a first step, you should discuss with the other parent your desire to relocate and attempt to agree on ways the other parent can maintain a meaningful relationship with the child or children despite any distance. If you cannot reach an agreement with the other parent on your own, then you should attend family dispute resolution and participate in mediation with a trained family dispute resolution practitioner. If you and the other parent cannot agree to arrangements at mediation, then you may apply to the Federal Circuit and Family Court of Australia for a parenting order that permits you to move or relocate with a child. If you or the other parent has already moved without permission, then the court may order that the child returns to their former residence. You could also seek a recovery order. A recovery order provides for the Marshal, officers of the Australian and Federal Police, or officers of state and territory police forces to locate and deliver your child to you. If family violence has forced you to relocate, you should obtain legal advice on an urgent basis. When you apply to the court will consider the best interests of a child as the paramount consideration. On an interim basis, so before the court has had the opportunity to hear all evidence and make a final informed decision about the proposals, the court is unlikely to allow relocation except in circumstances of urgency. There are usually 4 options for the court to consider on a final basis. 1, you can remain living where you are now. 2, both parents move with the children and remain near each other. 3, the residential or primary parent and child move away and the other parent remains behind. Or 4, the current residential parent moves away without the child and the other parent becomes the residential or primary parent, and the child continues to live in the same location. In deciding this, the court considers the best interests of the child, then whether equal time or substantial and significant time is in the child's best interests, and if those arrangements are reasonably practicable. Importantly, if you want to move, then you're not required to justify why. You should set out how the best interests of your child or children will be achieved by your proposal and how a meaningful relationship could be maintained with the other parent. If you wish to move with a child, then the important things to remember include: you should obtain the consent of the other parent before moving with a child unless you have a court order. If you need to apply to the court to obtain an order, then you should be prepared to set out why your proposal is in your child's best interests. All parenting cases, including those involving a move, are complex and unique. You should seek advice specific to your situation. If you have any questions about moving with children, then please don't hesitate to contact the family law team here at Turnbull Hill Lawyers.